Buenas and Hafide Todos Hamzu. This roundtable discussion by the Committee on Innovation, Economic, Workforce, and Youth Development is called to order. It is now 10:05 a.m. For the record, and in accordance with 5 GCA Chapter 8, subsection 8107, public hearing notices were sent out on Tuesday, October 3rd, 2017, adhering to the 5 days notice, and a second public notice on Friday, October 6, 2017, 48 hours prior to today. In addition, this hearing was noticed on the Legislature's website, www.guamlegislature.com, and written testimonies may be submitted by emailing Senator Bisco Lee at guamlegislature.org, or you may hand deliver them to our office at 163 Chalan Santo Papa here in Hagåtña. I want to thank everyone so much for joining us here today. We have a really good group to begin our discussion. We have some folks from our insurance partners. We have the Department of Labor here, the Workmen's Commission, and a number of other folks. We have some labor attorneys and other members of our community who are very interested in this topic. So again, I want to thank you all for your time and for joining us this morning. As many of us know, Guam workers' compensation laws were enacted in 1952. It has seen major or minor amendments but nothing substantial has really allowed compensation rates to increase proportionately with the cost of living. While many parts of the law need to be revisited and updated, I've called this roundtable today to initially focus on 2 sections of the law. So what we're going to dive into today is Section 9107, which is relative to minimum and maximum compensation levels, as well as Section 9109, relative to compensation rates for disability. The current rate of compensation for disabled employees is 66 2/3% of his or her average weekly wage throughout the continuance of the disability. For permanent total disability, the law currently sets a minimum amount of $150 per week and a cap of $250 per week. In regards to instances of disfigurement of the face, head, or other part of the body, the law currently states that compensation shall not exceed $10,000. These figures have not been updated since 1988. That was almost 30 years ago. And so, 1988, I was about 6.5 years old. So that kind of gives you an idea of how long we've been waiting to make adjustments to this. And currently, Guam's weekly cap is on an average $675 less than the weekly caps of all the other states. So it's clear that we need to revisit these figures. Workers' compensation is a safeguard for all of us as employees. In the event an employee is injured in their line of work, this law is what ensures dignity as they recover and rebuild their lives. And ultimately, if we don't provide adequate compensation on the front end, we all will end up paying for it in other ways, as these employees may have to seek help from other public assistance programs. Upon the recommendation of the Guam Department of Labor, I am working on a draft bill to update the law, starting with these crucial sections. The intent of my draft bill is to ensure that workers' compensation law is serving its purpose of adequately sustaining a worker in today's economy and with today's cost of living while he or she is unable to work because of an injury on the job. Today, I want to review and discuss the minimum and maximum compensation levels for disabled workers and the compensation levels indicated per type of disability. Pending a change of these amounts, I would also like to discuss the potential impact that would have on premiums for workers' compensation insurance. We are very interested in and open to your concerns and your suggestions on other parts of workers' compensation law at another time or in writing to this committee. But please note that the purpose of today's roundtable is specifically to discuss sections 9107 and 9109. And at this time, I'd like to invite Some of the representatives who've signed in, I have the Department of Labor here. Ms. Joellen Fullerton is the administrator of the Workmen's Comp Commission. We also have Mr. Greg Massey and other members from the Department of Labor. Thank you so much for joining us. And I'll just read off the other agencies or organizations that are here. And if representatives from these agencies would like to join us at the table, we're more than happy to have you. So representatives from Century Insurance, Great National Insurance, GNI, TNA, Calvo's Insurance, Moylan's, the Law Office of John Bell, the Society for Human Resource Management, the Guam Chamber of Commerce, and the Honorable Mayor Doris Flores Lujan from the Mayor's Council of Guam, who also sits on the Workmen's Comp Board. So again, we want to thank you all for joining us. And we'll go ahead and start with some written testimonies that have been submitted to the committee. Okay, so we'll go ahead and start with Attorney John Richard Bell.
Mic check. I did submit written testimony, so I'll keep it very brief. This is just very preliminary research, but consistent with what Senator Lee has said, it's been a long time since the rates have been raised. My written testimony did include other areas, but since the Senator said she just wants to really focus on 9107 and 9109, I'll just briefly recap. For 9107, the current maximum is $250 per week. It's apparently since at least 1988. In Hawaii, based on my very preliminary research, it's $812. New York is $870. California is $1,128 a week. And so my proposal is $1,000 a week. I know that's a big jump, but I think it's well justified given how long it's been since it's been raised. And again, that's a max. That doesn't mean everybody gets $1,000 a week. It just means as a maximum. I mean, if I've thought about it, if you're, let's say, a neurosurgeon making, a lot of money, you cut your hand off. I mean, you get $250 a week right now. And so I don't think $1,000 a week is out of left field given what is given in other states as a maximum. For visible disfigurement, my proposal is $30,000 again as a maximum, and that's in line with Hawaii based on my preliminary research. New York is $20,000 right now. We're at $10,000 under 9109, and so I would just support adopting essentially Hawaii's figure of $30,000. $30,000 for visible disfigurement, and $1,000 maximum for the weekly cap. Thank you so much.
Thank you, Attorney Bell. My office has also been working with Department of Labor and the Workmen's Commission in reviewing the workers' compensation law. We realize that compensation levels are not reflected of the average wage of our workforce today. And so I would like to pose at this time a couple of questions to the Department of Labor. So DOL, in coordination with my office, provided some initial recommendations for changes to the workers' compensation law. Can maybe Joanna Lynn or a member of your team explain how DOL and WCC determined these recommendations and suggested changes to compensation levels? Sure. Could you explain how the Department of Labor and WCC determined some of these recommendations and suggested changes to the compensation levels?
Yeah, what it was me and Joanne, my name is Manny Pablo, I work with the Department of Labor Workers' Comp. So me and Joanne we met with Greg and the director and deputy director. They already came out with some of the scheduling of what the fees should be. So we primarily just had a discussion with them, and we were not given the whole amount of what was actually going to be submitted to your office. But we gave an input of what we felt was necessary, but we never was given the total amount of what was actually given to your office.
This is the first one we've gotten.
So we're brought here just to go ahead and see what the hearing was about. But we never really got the final total amount of what was submitted to the legislature.
Because it was just a draft.
It was just a draft, yes.
Yeah.
Yeah, what had happened is we had coordinated with Joanne's office on what they thought would be a good update to the 250, and we'd kind of come to a consensus that 700 was probably a good number. As far as I know, we didn't really do any studies as to what's comparable in the other states, and we kind of figured that this process would be where we would be going through that. 7 was like a starting point, and then of course we knew during the legislative process that it was going to get kind of hashed out, so the 700 was basically what we suggested as a good point to begin with.
Okay, thank you so much. A draft bill would seek to lift the current minimum and maximum levels for total disability and instead provide benefits determined by 66 2/3% of the employee's average weekly wages. So can you maybe tell us what the coverage for disability is for GovGuam workers as compared to the private industry currently?
This is new to me, okay. For GovGuam workers, their TTD is full pay if they're certified to be off.
I'm sorry, can you just explain what TTD is? No, you're
temporary total disability. Do I push this?
Nope, you're good.
It's on.
It's on, okay. Temporary total disability is, they can get it for 5 years if the doctor certifies them to be off because they can't work because of their injury. Government of Guam have full pay. They initially, we don't give them the money. They get the money from their paychecks, from their divisions. So we just provide the medical, okay? And then when the doctor says to go back, they go back to work.
So they get 100% of their full
pay. Well, full pay, not counting differential pay, overtime. If they're $50,000, that's their full pay. Okay, that's what they get a year. But a lot of them that, like the police department and fire department, they make a lot more than that. So they really lose a lot when they're on TTD. So they get back to work as soon as possible. Okay?
And how does that compare to the private industry currently?
Well, the private is really hard because it's only up to $250, but that's the 22 GCA.
It's only up to $250
a week.
A week, okay.
We'd like to raise it, but that's what we're here for, right? Okay.
Okay. Do you think that using the 66 2/3% of the employee's average weekly wage will be appropriate for our workforce via this draft bill?
I think so. It's national. There's nothing wrong with 66 2/3.
Okay. What do you anticipate to be some of the results for the workforce and the insurance industry in removing the maximum and the minimum?
Oh, I think you're going to have to talk to the private here because there's going to be problems, but whatever comes up is going to be good as long as it's better than what we have now.
So what do you anticipate to be the results of that?
Well, I think if we can move it up to 700, that might be too much, I don't know. But also, if they wanted to go full pay, they can do like what we do. We have a couple of autonomous agencies that buy private insurance. And here's how that works. When a government employee is hurt, let's say at the airport, they have insurance with, let's say, Century. Okay? They get full pay. They have to have certification. They can't just say they got hurt. They get certification from a doctor. They get full pay, but the insurance company, if let's say it's up to $250, let's say it's $250, they send a check either biweekly or once a month, let's say $500 or $1,000, to that claimant who then endorses back to the airport. So it works very nicely that way. That might be a good way to think about this raise, where the employer will pay the full pay when their employee is out, and the insurance company will pay up to the whatever the 66 and 2/3 is
To reimburse them.
to the claimant, who would then sign it over to their employer. That would be a good deal. I think that's just an idea. I mean, they may have better ideas because I'm not an underwriter. I don't sell insurance, okay?
Understood.
And I know there's more to it than just saying $250 or $700. But if they go that way, then maybe the employers will treat their employees better, provide better service, safety, and then they will want their employees to come back. Maybe they won't terminate them because depending on how this comes out, when they're terminated, if you're on TTD right now, and the doctor says you're off, then you still get your up to $250 a week. So if an employer is now set up to pay the full amount for their TTD, but now they fire them, how is this going to work? Are they going to be paying that full pay? Or does that revert back to the carrier? So there's a lot of things you have to talk to the carriers here because I don't know how it works there. But there's I have different ideas. I don't know if it'll work.
Okay.
And maybe this way, it'll prevent the employers from firing them, terminating them.
Thank you.
It's just a thought.
Okay. Some states have linked their maximum compensation to a certain percentage of the state's annual average weekly rates. Do you think that linking our maximum compensation according to Guam's average annual weekly wage could be an alternative way to determine compensation?
I haven't thought about that. What do you think? It depends on what you all come up with. I think some of your questions need to wait until you talk to the carriers and you need to hear what they're going to say. Then maybe you
So I
all
have a
can make
number
a
of
decision.
questions for you, and then I have a number of
Okay,
questions
all
for
right.
the carriers.
I didn't even know I was going to speak. I thought it was all going to be private. Go ahead.
Okay.
We just knew about this Friday because you all had my wrong email. It's okay. All right.
Okay.
Senator, if I may, that might be a good methodology. It's a little bit better than just an arbitrary number. If that's the model that the states are using to determine,
Yeah, the 66.
But again, like Joanna Lynn said, I think the private sector stakeholder input would be a lot more valuable. I'm sure they've done, they're in the weeds of it versus the GovGuam system right now. So that might be an alternative to look at.
Okay.
Yeah.
Does DOL calculate Guam's average weekly wages?
I'm pretty sure BLS probably does. I'd have to check with the chief economist.
Okay.
I'm almost positive we've got something. Offhand, I'd have to check.
Okay, and then we
I
can
can
just
get back to
follow
you
up
on it.
questions with him
Sure.
and maybe ask him what the process is for determining the average weekly wage for Guam, how often, when it's published, how often it's published, and what our current average weekly wage might be.
I know there's, I think he currently has an average annual wage that we could probably convert down. Again, I'd have to check with Gary Howells on it.
Okay.
But I will get back to you on
And
that.
again, we just want to invite members of the insurance community, the insurance industry, to join us at the roundtable. If anybody has any feedback or suggestions at this time, we want to welcome you to the table. Just have a seat and introduce yourself.
Thanks. Good morning, Senator. I am Ray Schnabel. I am chairman of the Insurance Association of Guam, representing all property and casualty and health insurers. We applaud your efforts, and you're right, the workers' comp scheme has not been looked at in many, many, many years. And in looking at the draft legislation, I just arrived back from a long trip, and I haven't had a chance to go through this in any depth. Number one, no matter what we do in terms of benefits, et cetera, again, a cost is going to have to be estimated and split out, and rates are going to have to be derived. That's going to be very difficult with the lack of information we have with Department of Labor, with the insurance industry, et cetera. Even ourselves, we've been looking at this for many, many years, and we still do not have enough data to derive accurate rates. So no matter what we come up with, it's going to be an estimate that's going to have to be looked at over years. Number two, no matter what the benefits are, one thing that's been sorely lacking in the industry with regards to GovGuam's workers' comp scheme and the private sector scheme has been the lack of practical recourse. We say no, GovGuam's workers' comp says no, that's not workers' comp, and workers are left without practical recourse. In fact, as a representative of the health industry, GovGuam workers' comp says no, and we're left without practical recourse. Who do we challenge? And that's not built into this law. And you mentioned commissioner. Which commission and commissioner are we talking about?
The Workers' Comp Commission.
I'd just like to say that as a member of the chamber and as a representative of the insurance industry, that's something that we would strongly object to, having to answer to a workers' comp commission. Or, I'm sorry, a government of Guam workers' comp commission.
Do you have anything else to add, or? So I have a handful of questions for you as well, or any other members of the insurance industry if they'd like to.
I'm going to ask Nancy because she prepared some statements on just some of the philosophies that are lacking in the initial draft.
Okay,
Nancy,
thank you so much,
Nancy
Mr.
Tan.
Schnabel. Thank you.
Good morning, Senator, and good morning, everybody. My name is Nancy Tan, and I am the Education Committee of the Insurance Association of Guam, and I'm also the Assistant Manager for FirstNet Insurance, which is a domestic insurance carrier that does sell workers' compensation policies in Guam. At the moment, our Guam rates is actually the 1971 Hawaii rates plus 12% and 20%, and those increments of the increases were done maybe like in the 1980s, right? Maybe Manny can correct me on that, but so the rates by itself has not been changed either. So it kind of like corresponded as what Chairman Schnabel had mentioned, that if you should increase the benefits, then the rate should appropriately be adjusted accordingly too. Okay. The points of our discussion is basically in reviewing the proposed law, without a workers' compensation law, an employer can only be held legally liable for injuries sustained by an employee under common law if negligence can be imputed on the employer. The extent of such liability is unlimited. The employee, however, must prove it in court, which can be long, tedious, and expensive process for both sides with uncertain results. And the other thing is, for the elimination of the law, the need of the employee to prove negligence only that the injury or sickness is work-related. The benefits are specific and limited, except for medical treatment, which makes the program bearable on the part of the employer or the insurer if the employer chooses to insure the risk. Giving 100% compensation for us, the way I'm looking at it is, it'll be the weekly compensation entirely will induce malingering on the part of the employee, which is contrary to objective of the workers' comp law. So what's going to benefit me to go back if I'm getting full compensation anyways? Right? I mean, so in the private sector, we have to be wary of that if the employee is able and to go to work, then of course he should go back because he's only being covered 66 and 2/3%. I agree that the percentage may need to be adjusted, but as you know, economics is if something is adjusted, the other side will also have to be adjusted, right? So my other 2 points is all states and territories continue to impose maximum limits to their weekly workers' compensation disability benefits except American Samoa. The limits vary from state to state depending largely on the economic situation prevailing in each region over time. And thank you to Attorney Bell, he has showed us that. And so the consequence of changing the limits is any increase to the benefits limit will cause the employer and or the insurer more. This, therefore, should be the subject of an in-depth actuarial study to determine the impact to the employer, who must either pay the increased benefits himself if he chooses to self-insure or pay the additional premium that would necessarily be charged by the insurer. We have had several cases over the past year already wherein the employer has actually paid, our policy actually has paid over and beyond for the employee. Like, for example, if everybody can recall, there was an injury wherein the employee from a GPA transmission line, probably sometime in Telefofo, and we had to medevac the employee to the Philippines. That medevac portion by itself is close to $80,000, okay? So, and then of course our current workers' compensation law, the medical payments it's unlimited medical payments. So if the if the employee is still going through physical therapy, or it's under workers' compensation because it's a work-related injury. So these are the things that we really have to be be strictly aware of what we're getting ourselves into. The studies really will have to be very in-depth. That would be my recommendation. Okay, thank you.
Thank you very much. We also, I want to note for the record, we have some other representatives from agencies and organizations joining us. So we have GFT, the Guam Federation of Teachers, CC Law, IHC, FNI, TMPI, SOMPO, Pacific Indemnity, and the director of DISID is here with us today, as well as Guam Insurance Adjusters and PIICO. So if anybody else, any other representatives would like to join the conversation, please have a seat at the round table. Mr. Sharma, did you have any comments to add? At this point. Okay.
Can I just give you a quick synopsis of the Chamber's perspective?
Thank you, Mr. Shringi.
Good afternoon, Senator. My name is Bobby Shringi. I'm also the chairman of the Guam Chamber of Commerce. And just like with GFT, the Chamber is still drafting a position. Actually, a draft has been created. I'm just waiting for the board to approve it. But just to kind of sort of give you a synopsis, and I think the sentiments are very similar to what Department of Labor as well as Mr. Schnabel has stated. It's really difficult to really put a position because there really is no real numbers on the table. The primary concern, of course, is the cost factors. You know, we represented, by the way, I'm also with an insurance company, but my comments at this point represent my hat as a member of the Guam Chamber of Commerce. And so our concern primarily is, how does this impact the small guys? You know, insurance premiums, as we all know, can escalate. And Ms. Tan here also mentioned that if 1971 rates have been utilized and if there are changes to the benefits, then obviously it's also going to eventually lead to changes in premiums. You raise the caps, suddenly there's going to be a cost factor. And while the big entities may not feel that burn It's the little guys. It's the 5-man operations. It's the 7-person operations. And these are things to consider. So that's really where we're at. Secondly, and in our draft, we've also noted the recommendation of a study, of a true actuarial study, to see exactly where it should be. I'm pretty sure at this point it's a given that the conversation is sort of heading in the direction where these caps will be amended. But to what level? Where should it be? And I think that's where a true actuarial study really must be conducted to determine that. I mean, arbitrarily saying 700 or 1,000, it's nice to put out numbers, but how does it impact premiums? How will it hurt the little guys? These are things that have to be questioned as well. So that's basically where we're at this point. But we'll be submitting a official, as soon as I get my board to approve what was drafted over the weekend, which, by the way, once again, is based on this specific draft and not necessarily what the ultimate legislation is going to entail. Okay? Thank you.
Thank you very much. I do have a few questions for maybe Ms. Tan and Mr. Schnabel. I'm not sure, maybe you can both answer some of these, but I just want to learn a little bit more. Maybe you can tell us a little bit more about disability coverage through workmen's compensation, and more specifically about maybe your company, specifically by your company. So what are the types of claims or injuries that you generally cover?
Well, as long as they're work-related, an injury is an injury. I mean, like, for example, if it's a construction company, like our worker in Telefofo, he was basically covered for all of the medical expenses, plus also a portion of it was during as temporary, the temporary total disability, and also the permanent total disability also at the end of the assessment of his doctor. So it's, well, if, like, for example, well, workers' comp, like, let's say if I'm traveling to work and I have not reached work yet, okay, and I get into an accident or something, so that would then be workers' comp, okay? As long as I'm at the workplace and it's part of my duty, during off hours or whatever, that will be a disability, because that will be the coverage, basically, yeah.
And you also, in your remarks earlier, you were noting that there hasn't been a change in premiums since the 1980s. Can you just confirm that?
I believe so. Because I started in, I've been in the industry for 31 years, so I've only seen one change. Can I put it that way?
Okay.
I think it was 1995, I believe.
So yeah. 1995, there was an increase?
1988.
Was it 88?
Yeah, and as I've mentioned, the increase was a gradual increase. It was a first 12% increase of the 1970 in Hawaii rates, and then a couple of years later, a 20% increase. Am I correct on that, the insurance people? So it's, I know it's like 12 and then 20.
I think that's good enough. It's been a long time.
Yeah, it's been a really long time. Okay.
Yeah, and actually the previous regulatory administrator, Mr. Carlos, did suggest to look into this also. He had suggested this before his retirement. So as Chairman Ray Schnabel had mentioned, yes, we are considering doing that and looking at a more concrete study, but it's just that we need the industry's data also, and then probably the government of Guam data also to be shared, although the benefits are actually a little bit different. Yeah.
Can I just provide one more word of caution? Basically, it's already difficult enough trying to estimate a cost. That's been one of our challenges. How do you estimate cost? Even under the current workers' comp scheme, it's been very difficult to estimate that cost. Now, when you change the landscape, it becomes much more difficult to estimate future cost. And one of the necessary things behind estimating cost and insurance is quantifiability. When you make benefits without maximums, it becomes much more difficult to quantify. We struggle with that on the medical side because it is unlimited, and the medical side is also subject to large increases in inflation. So it's always increasing, and it's unquantifiable. So it becomes very difficult to keep track of that cost. And that's one word of caution. If whatever transpires in the legislation, if it can be done so that we can quantify cost more easily, that would be better.
One of the things that was mentioned by several of the people at the roundtable were that an in-depth actuarial study should be considered. What is your, oh, go ahead.
Like I mentioned earlier, because of the lack of data, you can have a team of actuaries looking at it, but without large quantities of historical data, any conclusion they come up with is going to be not very good. So at the end, no matter what studies we do, at the end we're probably going to have to just come up with estimates and just monitor that over time.
Understood. Okay, thank you very much. Also at this time, we have representatives from the Society for Human Resource Management, Joanne Munya, and Mayor Doris Flores Lujan. They can join us and just provide your testimony. Go ahead, Ms. Munya.
Hafaday, Senator. Thank you very much for inviting us to this roundtable. I'm glad to hear that everybody agrees that this is overdue in terms of at least looking at the 66 2/3 average weekly wages not to exceed $250. More than 25 years ago, I've been working with workers' comp. That's where I first started within the government of Guam. And I'm sad that it's been such a long time that anybody really looked at this very important law. One aspect is, yes, we do have to change the maximum of $250, but I agree with everyone else, there has to be a cap. Unfortunately, our organization does not have a recommendation of a cap yet. Like everybody else, we have to do a study, we have to survey our members, and we want to present something that is concrete and makes sense for the entire community. But definitely we need to have a cap. So with that said, we don't like the whole strikeout of your draft. So we will be preparing some recommendations. Additionally, Joanne from Department of Labor had stated that the government of Guam employees get 100% of their compensation. My other role is I do work for the Guam Community College. And it is true that we do give our employees who sustain an occupational injury or illness 100% compensation through administrative leave. There is a cap of 90 days. That is the one major change that was made with workers' comp in the past several decades. I'm not sure that's what I would recommend for the private sector, only because I believe even with utilizing that within the government of Guam, there are some gaps and holes. So we may have to visit that as well. I'm certainly interested in seeing what the insurance companies would like to propose. One gentleman mentioned also commissioner. What commissioner? I think that not just looking at this section of the workers' comp law, I think we have to look at it as a whole, because decisions made with the commissioner, who are the commissioners, who are their makeup, what are their roles, also has to be looked at and changed. So my recommendation to you is perhaps, you have a lot of very intelligent people in this room, is maybe put together a working group from all the different industries and have that working group work together and see how they can, as a group, look at what are the areas of the laws that we can change. What are some of the immediate changes we can make? And maybe it's that 66 2/3 with a cap. and then look at what are the long-term changes we can make as to the whole structure of the workers' comp law. And you are correct, this is the one law that definitely affects all employees and all employers. So the Society of Human Resource Management is more than happy to be a part of your working group, but we can't do it alone. We have to hear from the insurance companies, we have to hear from the employers, and we definitely also have to hear from the employees. So I thank you very much for the start of the conversation.
Thank you very much. And we also have, ma'am, if you want to just state your name for the record.
My name is Margaret Cruz, and I'm representing the Guam Department of Education. What I would like to see here in this bill is something added on or amended to the bill, because we have numerous employees in the department who are part-time limited terms. I'm talking about one-to-one school aides who work with special need kids. Upon injuries, the only compensation they get is medical bill and for therapy sessions, or in order for them to get back into the work society. However, unfortunately, they don't get compensated for the time that they're out due to injuries by students. So how can we help our employees to add that into, or kind of like amend that into part of the law, because they don't get compensated for work, for times lost?
That is, okay. Yes. Are these people under grants? Because that's the GDOE rule. That's not ours. We would love to pay them, but it's GDOE that's not paying them leave. They don't earn leave. They don't earn anything. So is it on a grant? Is it something that's written in one of your SOPs? Because we would love to pay them when they go. There is a few that don't get anything at all. They've been working a long time for GDOE, but GDOE doesn't give them, they don't earn leave, they don't earn sick leave, and so when you don't earn any of that, you don't get any compensation from workers' comp, but maybe you need to talk to GDOE about that, because they have to change their rules so they can pay them and earn leave. Is it a grant? See, we don't know. They just come when they're hurt. They get beaten up. And we take care of them.
They're not covered by grants.
So are you saying that we should have a section in the 22 GCA to cover them?
Yes, that would greatly help, so that they can follow through and ensure that those employees do get that. Because it's not just one-to-one aides, but we also have limited term teachers as well.
Yeah, you know, Margaret, back in the 90s, like in 1995, 96, DOE employees did not get temporary total disability. They never got the $250. It was enacted upon your Department of Education's regulations that state that they should not be getting that. It was changed, then you got the $250, then you started following. We had this problem back in the late 90s in regards to these one-to-one aides not getting paid, but basically they don't get work, they don't get sick leave annually, they get no benefits. So that was based upon your statutes with the Department of Education. We would like to have helped them provide them the compensation, but because it was not in your statutes, we could not have done so.
Okay, only because as limited terms, they don't earn leave.
That's what I mean.
Right, they don't earn any type of leave. So when they don't work, there's no type of leave afforded to them.
But if you would,
but it's not just DOE that follows that. That's strictly across the board with limited terms.
But you're the only ones that we do not pay the TTD for. If you're on a grant, if you're under contract, we will pay the temporary total disability till the contract expires. Okay, but DOE is the only one with employees that for the year, 2 years, or 3 years, one-to-one aides, particularly that position, don't get monetary compensation. Get medical compensation, but not monetary.
Thank you. And Ms. Cruz, can you just, for the record, state your role? Is it at DOE, or are you here as a private individual?
My role there is the Equal Employment Opportunity Officer, and I'm also the designated Title IX coordinator for the department.
Thank you very much. And Mr. Schnabel had a comment?
Basically, as an employee, and a taxpayer, I don't see any logic why the government of Guam and their employees are under a different set of laws, benefits, and structure than the rest of us.
Thank you.
John?
Mr. Bell. Attorney Bell?
Thank you. And it's sort of a general comment. I wanted to address what, quite frankly, could be the elephant in the room. And so what I would say is the insurance industry here is very well represented, as they should be. And so, and I will preface this by saying we want the insurance industry to do well. We want them to stay in business and make good profits. But I think maybe not any intention on their part, but without any finger pointing or blame, I don't think the system has worked very well. I've talked to a lot of people from the insurance industry and even opposing counsels, and everybody agrees that they're not happy with the way the system is working. And everybody agrees that, generally speaking, for the injured worker, it's really tough to get their benefits. It's a lot of it's basically an honor system with the insurance adjuster. They'll either pay the benefits or they don't. And if they don't, what does the employee do? And frankly, there's not much they can do about it. And about once a week, I'm having people come to me and ask me for my help, and I'm saying, we really need to reform the system. So, but that's maybe for another general discussion. But the reason I bring that up now is because what we're saying is, and I understand where the insurance company is coming from. I'm proposing a significant increase in benefits. And so what the insurance industry, I understand them to be saying is there should be a proportionate increase in the premiums that the employers pay. I pay all of like $300 a year for my 5 employees, which I think is really low, and I'd be happy to pay a little bit more. But what I would say is, what I would look into is, what is a reasonable profit for the insurance companies? Because I'm not saying that the insurance companies should bear everything. I really want a good faith discussion. There's 3 main parties. You've got the employees, you've got the employers, and then you've got the insurance company. And I think the question should be, what is the appropriate balance? And so I just don't think it should be taken as as gospel that whatever appropriate increase in benefits needs to, correspond to an exact, proportionate increase in premiums to the employers. I'm not trying to go after the insurance company. Again, I truly want them to make money, but what I would say is there's something to look at, because the numbers that I have seen, I think there's annual reports, and I'm afraid to quote, but I will guesstimate what I thought I read, which is somewhere in the ballpark of $15 million a year paid out in premiums and about $5 million a year paid out in benefits. And so if I'm way off, great. I want to be educated on exactly what the numbers are and how, the insurance companies, the employers, and essentially the injured workers can all come to some round formula that everybody can live with.
Thank you very much. We also have the director of DICID here with us. So, Mr. Sorvino, do you have any remarks that you'd like to add to the conversation?
Thank you. For the record, my name's Ben Sorvino. I'm the director for DICID. When I apologize for running late. We're doing our NDEEM workshops this whole week. But when I received the bill, the draft bill, I was a little concerned about the intent of why they were removing the maximum minimum. And again, trying to figure out what was the motive, what was the intent, what was the process of thinking of that. And I start to research the federal guidelines, and they still have the maximum minimum rates for compensation of disability cases, and for total or partial disability, it may not exceed 75% of the basic monthly pay. And then for the loss of, again, a total disability, may not be less than 75%. So they're using that ratio. The loss of body parts, as I compared them with the rates that are in the bill, they're basically similar, but it's a little lower here than it is in the federal guidelines. And I was assuming maybe that's one of the reasons why this bill is being introduced, to try to get up to par to the federal guidelines and at least be compatible to that. Most of the concerns that I've been handling for our constituents with disabilities involves, again, they're not knowing what the benefits are. And especially for the contractors that are here, when they employ people and then, they have an incident, an accident in their work site, a lot of the employers don't really, again, advocate for their employees. And some of our constituents come to me complaining they weren't given the information to make an informed decision about what their rights were, and they were at total loss. So I'd always have to refer them to the Guam Legal Services Corporation, because, again, DICID is not an attorney. We don't provide legal advice, but we're just concerned, again, about the discriminatory acts that occurs as a result of them having this disability in the work side. And the ADA is very clear, again, about the information from the workers' comp claims that can't be used if they are to go out and try to pursue another employment opportunity, and employers cannot take that information from the workers' comp case unless they are given an opportunity for a conditional job offer. So again, the discriminatory concerns is one of the things that I've been brought to my attention from our constituents. And I just wanted, again, to stress that the ADA issues and also the rates that I'm seeing from the federal guidelines are consistent with the ones that is being proposed.
Thank you. And you had something to add?
Good morning. My name is Leilani Botha. I am the Assistant Claims Manager at Century Insurance. I am also the former administrator for the Workers' Comp Commission. Thank you allowing me to speak. In reference to Mr. Sorvino's question, as far as employers are concerned, now that I went from the commission side to the private sector side, I'm now with the carrier. So I have a different view as far as the work comp system is concerned. In reference to employers not having the adequate knowledge to inform their clients, this is where the carriers come in. This is where at Century, and I'm sure with the other carriers, and at Labor as well, we do a lot of outreach. We do training with our insureds. Our customers and clients and companies are welcome to contact our office. If they doubt whatever advice we provide, we refer them to the Commission's office, who also provides guidance. So really, it's a matter of putting out that information, letting the employees know what is available by law, you know, from employers. So I think awareness is very important. We should all just kind of unite to spread awareness. That way everyone's on the same page, right? So every work comp claim has three parties: a carrier, an employer, and an insurance company. So we all have to work together in addressing the issues here. I am aware of Joanne. She was there before I went there, so I'm happy to see her here. But if for Mr. Sorvino, for your constituents coming in, I would recommend that every company that has work comp insurance is given a notice board that is issued by the Commission that's to be posted for their employees to see. So encourage them, please, to find out who their work comp carrier is, ask their employer, their HR. They can then direct them to the proper insurance company, and they can be guided accordingly. They should be able to be walked through. So other than that, instead of an attorney, which, by the way, those fees come out of their own pocket, then please, you know, utilize the Commission's office, call their carrier. That's what we're here for, to service the employees. I would just also like to make a few comments as far as the discussions that's being made here. On the table is the raising the minimum, maximum, maybe eliminating it, the TTD, the compensation, as well as disfigurement. So the way I see it, there is the full pay. When I was at Workers' Comp, they actually had that in place where government of Guam employees had full pay status when they were out of work, and the only requirement was for a doctor certification. Now, in my experience there, and Manny can relate because we worked there together, was that there was much abuse and fraud. We're going to be realistic. This is government of Guam. Everything is budget driven. There may not be enough funding, and this can also be mirrored with the private sector. When a person is injured and full pay status, the way the work comp works is it's an automatic benefit, it's a no-fault benefit. And if it's covered, the burden of proof of denying that claim is on the employer and the insurance company. So by presumption of coverage, that employee is automatically covered for workers' comp benefits, and the law tells the carrier what to pay and when to pay. Okay? So they don't need, we don't, if there's any injured workers on this island that have that predicament, call your carrier. If your carrier's not listening, call the Work Comp Commission. That's what then that enforcement agency is for. So the purpose of the law is, of course, to eliminate the suits between the parties, but also the goal of the carrier is to get that injured worker better, full maximum recovery, assist them with the work comp benefits, and back to the general workforce, because we don't want that employee to be someone that has to be reliant on public assistance. So as far as the maximum minimum, the compensation, I agree. 1988, 1952, we do need to make some changes, and I agree with Joanne. Not only will those sections need to be changed, but there's a lot of gaps and a lot of ambiguity, a lot of gray areas in our work comp law. And being in the field, there's a lot of players here that can provide that valuable input on what those changes can be. So the way I see it as far as the compensation is the full pay is not going to cut it. They had that in the government. They removed it during the time I was in government, and then when I left workers' comp, they put it back in place. Completely understand that the injured worker is at a financial disadvantage, but at the same time, I agree with Nancy and everyone else around here that that is not going to prompt the injured worker to get better. As a carrier and adjuster and working with work comp, you're going to come across those injured workers that malinger, that fraud. And the purpose is that puts the employer and the insurance company in a predicament, because not only do we have to hire an investigator, hire our lawyer and have litigation and court fees, but we also have to do surveillance. We also have the burden of proof of disproving that work injury is legitimate by, for example, there are not enough specialists on island. So because of that, we have the burden and the responsibility, not burden, let me take that back, the responsibility of taking care of our client. So remember, the objective is to get them better. If we don't have specialists here, and we've been trying to work with the healthcare providers to get them here, we have to send them off island. For example, Philippines. Now, that may be great for personal health insurance, but they have no clue what the workers' comp is all about. They do not do impairment ratings using the American Medical Association guidelines. They have no clue what the requirements are for us to properly compensate a claimant. Stateside, a lot of them don't know where Guam is, they don't trust the insurance companies, and they just prefer that our client pays out of pocket. So establishing relationships, whether it be in the mainland or in the Philippines, is difficult. And that puts us in a predicament as well. So just like there's that check and balance, you have the rates, the premium rate's going to go up. We kindly ask that the office also look at the carrier and employer side, in that the purpose of the law is to assist the employee or the injured worker, get them better, make them comfortable where they can still pay their bills and not have to worry about not paying their bills or getting their house foreclosed or whatnot. But I truly believe that we should look at the Bureau of Labor Statistics. Mr. Gary Hiles is excellent. We can get a statistical 10, 20-year period of the cost of living, the state average, right? And maybe, hopefully, we can set a minimum and a maximum, you know. And it's really, to me, the dependent of our economic environment. As far as what I wanted to share as far as the carrier side is that, let's see here. I've just been writing like crazy, so forgive me. I think that's basically it, is instead of just kind of looking at the full pay, to me is completely not an option. As far as 66 2/3 of the person's average weekly wage, I still truly believe that's kind of right below full pay status. I still feel there should be a maximum. In reference to disfigurement, I know that there is a proposal to go from 10 to 20, and I ask that that entire statute, not only the amount being set, but the wording of it, because it says serious disfigurement of face, neck, and other parts that are visible during one's employment. I think that's too general. The reason why I say that is we feel that if a person, first of all, if they get injured, Senator, on their hand, they're a construction worker, carrier's already paying a PPD, permanent partial disability compensation, aside from TTD, right, for that impairment, okay, for the loss of use of that impairment. But then as a construction worker, the doctor discharges that employee, he is able to go to full regular duty. So he's already being compensated for lost time and permanent impairment. And then if we do disfigurement, how is that disfigurement going to affect his ability to earn wages, right? He's still earning the same wages that he was before. So another scenario, we have a model who got injured. Let's say she had facial burns. Now, as far as disfigurements, I completely understand why we should compensate her as a third compensation mode, because that is her ability to earn wages. So I think the amount of disfigurement and this where it says serious disfigurement, I think that the definition itself should be incorporated in 9104 in the definition section of the law. Anyone can misinterpret serious disfigurement. And instead of and if we could kind of see whether or not that disfigurement, add to the statute, whether or not that disfigurement affects the person's ability to earn wages in the future versus it being visible in employment. It just doesn't make sense. I have some clients come in and they have a cut and it's a scar, and he's a construction worker. He was demanding $10,000. How am I going to justify that? How rash, that just doesn't appear reasonable at all. And he was compensated accordingly. So that's just something that, that I'd like to share. Thank you.
Thank you very much, Ms. Botha. Yes, Attorney Bell.
I do want to keep it short, but since, the issue of essentially kind of hinting at perhaps bad faith claims on the part of employees has been brought up as an issue, I won't use the word bad faith, but what I will say is, again, countless employees have come to me and it's the same story. And they come, did you report it to your employer? Yes. Did you go to the Workers' Compensation Commission? Yes. And so the insurer won't pay it. And so without getting to the nitty-gritty details of every case, there are employees today, some of them I represent right now, or we're just denied a hearing. We've asked for a hearing, we just won't get one. Why not? No explanation, we just won't get a hearing. And so certainly the employee is the one that loses, right? When the system's not working for whatever reason, if the system's not working, they don't get a hearing, the insurance company they're okay. They keep that money. The employer doesn't care. And a lot of times the employer has fired the employee, and so who's really loses out by the system not working is the employee. And so I think that's a real problem. I think I really try to save this discussion, and certainly I'll leave it up to the senator. But it's brought up, and understandably, I want the system to work well for the employees, and I want them to get hearings, and I want them to have, some meaningful recourse, and admittedly, and that will probably increase payouts, and so absolutely, and I'm trying to really truly be very transparent about this. That means the insurance companies are going to be paying a little bit more, and so I'm totally fine with checks and balances on both sides, absolutely. I mean, and the underlying problem that I think can be addressed is if the mechanics of the system just work well, right? Ideally, and I truly mean this, oh my gosh, I have better things to do than workers' comp. I really don't want to, I'm not even kidding, I don't want to do workers' comp, but employees come to me literally once a week on average with the same story about how they reported it. They did everything that they're supposed to do, but there's just nothing that they can do. They can't get a hearing, and so they have to come to me because they've been to workers' comp, and nobody will help them. And so, in short, if there's just due process and on both sides, right? That's a neutral thing. I've actually been surprised. It's been refreshing to talk to defense counsels, and they're like, "Oh man, you too? I feel the same way." I wish we just get a hearing and everything worked a little bit better. So, I think that will address that. If we want, I think obviously workers' comp claims should be adjudicated on the merits, and so they should actually have their chance to actually have. Whatever form, administrative hearing officers, the board, as it's designed, with a medical officer there, or a doctor, a lawyer, and other people from the community. The problem, from my perspective, speaking on behalf of literally dozens of people with the same story, is that they're not able to even get that. They're not getting a hearing. They're not getting their day in, not in court, but they're not getting that hearing to determine whether, in fact, as a matter of fact, and law, they are entitled to workers' comp benefits. So.
Thank you, Attorney Bell. You also mentioned, I think in your testimony, that you wanted to discuss the funeral benefit.
Absolutely.
You recommended a funeral benefit?
Sure, and in preparing for today, I just kind of looked at, all the different compensation levels, and so I have compared to other states as well. Funeral expenses on Guam, it's $3,600. And so my proposal is $10,000. I know that's a big increase, but in New York it's $10,500. And I think it's worth noting that our statutory scheme is essentially adopted from the New York scheme, New York and/or Longshore. And so they're all related, but basically New York's workers' comp scheme. So in New York they get $10,500, and California has $10,000. Death benefits, Guam is $250,000. Sorry, Guam is I believe it's $100,000. Honestly, I did the weekly thing, but it's $100,000. I'm proposing $250,000, right? If the employee dies, I mean that's somebody's life. I understand it's not a make-whole system, but just to say that this isn't out of left field, in California it's $320,000 based on my preliminary research. New York it's $870 a week to the family. And I know that there's going to be sticker shock here, but I'm proposing for lifetime disability for the injured employee, it's $100,000. And think about that for a moment. If you're a 22-year-old warehouse worker, for example, or a 19-year-old, it's not inconceivable. I worked blue-collar jobs until I was 30 years old. I have a bad back. I never filed a claim. I should have. But you get the idea. Imagine you're 20 years old. You break your back, literally. I had a client with a crushed spine. That kid gets $100,000 for his entire life to feed himself and his family. My proposal is definitely big. It's $500,000, but again, that's lifetime. I mean, you do the math, $500,000 over maybe another 75 years of this person's life, theoretically. And so that is a big number. I certainly understand there would have to be give and take as well in terms of raise premiums and stuff, no problem. I can only speak for myself as a small business employer. I am the cliche small business just trying to buy used furniture and buy the cheapest coffee and to try to stay in business. But I certainly would be happy to pay more in premiums so that my employees have real meaningful remedies available to them.
Thank you, Attorney Bell. Also, Director Sorvino, you were mentioning the National Disability Employment Awareness Month. Did you have any other input that you want to share with the community about upcoming events or activities before we wrap?
Yes, thank you. Tomorrow we're having a one-day conference at the Hotel Nico and targeted to employers and job seekers with disabilities, and this is all free. We invite you to come and attend. We have a series of workshops throughout the month focusing on reasonable accommodation issues, the obligations of employers and federal contractors under the Section 503 requirements. And then at the end of the month, we're going to have a job fair targeted just for our constituents at our office. So it's in our website. Just go to www.dicit.gov, and it's all there.
Thank you very much. I'd also like to ask if Attorney Diaz could join us at the roundtable and perhaps summarize her article. And if just another general invitation, if there's anybody in the room today who would like to go on record or speak for this roundtable hearing, it's kind of a last call. Please let staff know.
Thank you so much, Senator, for having me today, and thank you so much for taking an interest in taking a look at the workers' compensation laws here in Guam. I'm with Camacho Calvo Law Group, and just in terms of my background, I moved back to Guam in November 2016 after having been away for about 20 years. And while I was in the States, I was a workers' comp defense attorney, wherein I handled workers' compensation claims, and I represented a number of insurance companies and employers. And so it was quite eye-opening to come to the island, and the first thing I looked at when I looked at the code was what's going on in workers' comp, and I was quite shocked at the fact that the rates hadn't been changed since the 1980s. And so I wrote a few articles, one of which is this workers' comp reform article, and the basis for that is these temporary disability benefits that we're talking about. They're meant to ensure that our injured workers have enough time to adequately recover from their medical injuries and not have to rush back to work. And there's so many reasons why they should take the time to recover and still be able to support their families, to pay their bills, put food on the table. So the benefit for the employee or the injured worker is that they get to still have some sense of dignity. They're not relying on the system in terms of public assistance or anything like that. They can still feed their kids. And for the employer, I mean, if you've got a really good worker who you really want them to get back to work, instead of having to hire somebody else or to train somebody else to cover that position, you want to make sure that they're not rushing back, because if they do rush back, who knows what other kind of injury they may sustain, or they may aggravate the injury that they already have. And so I'm really happy that you're taking the time to look at this. I like the idea, and I forgot your name, I'm sorry, you're with Sherm. Joanne. I like the idea of having a roundtable discussion with all the major heads, the insurance companies, the employers, the employees, and everyone affected to put the numbers together and to figure out what works, because we need to make sure not only that we take care of our injured workers, but also that the insurance companies don't go bankrupt. So when I was practicing in the States, there were 2 major reforms, and they had to go through these reforms because you can never get it right the first time. And so with the first reform, they increased benefits, and they realized, uh-oh, that didn't work, because the insurance companies, their rates were going up, the employers were complaining, they couldn't afford workers' comp insurance. And so with the second reform, rates went down, the injured workers suffered a little bit in terms of benefits, but they're making it work with these little changes as you go through. So I will be submitting something to you with regard to everything that was said today and giving you my input, but thank you for your time this morning.
Absolutely, thank you very much. And really, thank you to everyone for being here today, for providing your expertise and your insight on how we should move forward with updating this law. Your time and your input is essential as we look to bring workers' compensation levels up to date. And updating these rates will ensure that any of us who might find ourselves in unfortunate circumstance of being injured and disabled on the job would be appropriately supported as we make our recovery. As I work on legislation to update sections 9107 and 9109, your comments here today and all the ones that I receive in writing will certainly be taken into account. And so I'll be working with the committee to review this roundtable hearing and all the ideas and discussion that we had today, especially the idea of coming back and having additional working group sessions with all the stakeholders. We know that there are other areas of the workers' comp law that need updating as well, and I look forward to hearing from you after today on your suggestions for that. So with that, I just want to say, Sidus Maasi Todes Hamdu Purifinatin Mizu Pagu. This roundtable hearing is now recessed. Adjourned at 11:19 a.m. Individuals who wish to submit additional testimony will have 10 days from today to do so by emailing it to Senator Bisco Lee at guamlegislature.org, or you may hand deliver it to my office right here at the Guam Congress Building, 163 Chalan Santo Papa in Hagåtña, Guam. Sidus Maasi, and God bless you all. Thank you.